over the course of several years now. I can promise you all that if you have a thought about what a Chin statute may be interpreted as, and it's different than Richard's, you will be wrong. And he will cite numerous sources and numerous other statutes to show you nicely that you are wrong. So Richard is a great resource as well. He's always been very accessible. I don't know if anyone else has tried to reach out to him, but if there is a sticky case or maybe a question about an interpretation, he's always been very helpful in pointing people in the right direction. That includes with DCS policy, which, as we all know, can be very convoluted at times. So with that said, I will turn it over to Richard, who's going to give us some information regarding DCS cases. I think he's also going to touch on expungement, which I know we as practitioners get quite a few requests about. It's a very different process than criminal expungement, and oftentimes I think we probably get it wrong. So, all right, Richard, good luck.
Thanks, George. As George mentioned, I'm Richard Kleindinst. So in my role as Chief Counsel in Region 3, I supervise the 19 legal staff in St. Joe, Elkhart, Kosciuszko, and Marshall counties. And I've been with DCS now for almost 12 years doing this work. And I'll begin with the obligatory disclaimer. I'm speaking today in my personal capacity. So any views I express on interpretations of particular statutes or DCS policy are not the official position of DCS on past, current, future matters. Need to put that out there. And this presentation is pretty informal, so feel free to interrupt, ask questions if you have any, or points of correction. I see a couple judicial officers, current and former, on here. So if you think I got something wrong, or anyone else, weigh in. We'd like to hear from you. And really, I tried to pick out several topics that are of general concern or applicability for family law attorneys practicing in the area. So even if you may not frequently appear in child in need of services or termination matters, I tried to touch on some issues that I think may come across your desk, or you may have someone give your office a call and say, hey, I need to address X, Y, or Z. Can you give me some guidance? So there were really 6 of those topics that I focused in on. And so hopefully they'll be of some use to you. And obviously, if you have questions about the sites or the things I reference, we'll hopefully have some time at the end to talk more about that. So quick overview. I'm just going to speak briefly about the DCS legal practice model, because there's a little bit of confusion about that sometimes. I'm going to talk about expungements of CHINs and DCS records. I think we've seen an increasing number of those in the last couple years, with folks requesting that their CHINs records or DCS records be expunged. I'm going to talk about a couple legislative changes that took effect this year, impacting termination of parental rights and permanency planning in CHINs cases. I want to talk a little bit about adoptions. There was a recently announced change to adoption subsidies that actually just came out in the past week, and also talk about a little more dated changes, but those that are still important around the timeline to contest adoption petitions, which is important for a lot of parents out there, and a lot of adoptive parents, or a lot of biological parents counsel, aren't aware of the change time frame. So I wanted to mention that. I'm going to talk a little bit about custody and parenting time changes in CHINs cases, because that obviously impacts a lot of DC and JP causes. And then time permitting, I may mention a couple of things about guardianships where there's an active CHINs case. To get started, I have no doubt that many of you are already aware of this, and I know those who have practiced at DCS know this. DCS attorneys do not have prosecutorial discretion. So unlike the prosecutor's office, the organization as a whole, under the rules of professional conduct, are our client. So per the ABA, this means that, like other lawyers, we have the same obligations in representing our government client that you all would have with your private client. Our client representative most often is that family case manager that appears at various DCS hearings. And so this means a couple things. One, it means that we usually ask that communication with our client, with the family case manager, be directed through us as their legal counsel. So if you want to have a conversation with that case manager, it's just as with a private party, you reach out to their attorney. The other thing that means, which is pretty important and can be frustrating at times, is that Rule of Professional Conduct 3.1 applies to us just as it does the private counsel. And that means that if there's a good faith basis under the law for making a legal argument that our client wants, we're obligated to explore that and move forward. So we will advise our client of a recommended course of action. But ultimately, if the client wants to go a certain direction, even against our advice, and there's a good faith basis in law and fact for doing so, we are obligated to move forward. So I know that can be a point of frustration or confusion about why is DCS moving forward with X, Y, or Z. We may have had internal conversations and advised our client in a certain way, and they've decided to move a different direction. So again, if there's a good faith basis in the law for moving forward, there may be those cases where we think we're not going to prevail, or maybe we've advised we might not, but we're under an obligation to move forward. Obviously, we'll probably try to have some settlement discussions to come up with some sort of less formal involvement, but those aren't always effective, and sometimes that's not what our client wants, just as you all experience if you're in private practice. So I mentioned that just to set a framework for how conversations can go sometimes, and the fact that we have to take discussions back to our client, consult with the case manager, and really the DCS attorneys have to put forth effort to get their client on board to a degree with what seems to be an appropriate legal outcome. And that is a shift in practice, and it's not the model that obviously prosecutors and some other government attorneys have. But I hope it helps explain some of what we're trying to do and navigate, because it can be difficult at times. That out of the way, I wanted to talk about expungements first, because I think we've seen more in the last 2 years than I'd seen in the prior decade combined. And in two related provisions, the Indiana Code gives a mechanism for individuals to expunge records concerning a delinquent child or a child in need of services. And there's a mechanism to expunge substantiated reports that DCS has in its records. The latter is what we find that most folks are actually looking for, because it's a substantiated DCS history, which a substantiated report really means that a DCS assessment that found that child abuse or neglect occurred. When that happens, an individual is placed on what's called the Child Protection Index. And that's an index that DCS is required to maintain by statute. And it's functionally a repository of those who have been found to commit child abuse or neglect in a DCS assessment. And what will happen is we'll usually see that someone will apply for a job. Sometimes it can even be a janitor job at a school. It can be helping out at a licensed daycare. Sometimes they're going back to school to be a teacher, so they want to substitute teach, something that works with children. They'll apply for a job and they'll get a result saying that they didn't pass their CPI or Child Protection Index check, and so they're not eligible for employment. Most often that's when they'll reach out to one of your offices if you're in private practice and say, hey, what do I do with this? Like, this is from, sometimes it's from 15, 20 years ago, and it's keeping me from getting this job. And so I want to talk a little bit about next steps, because it is not always a clear process. So I guess first I'll say it's important to know which expungement your client is actually seeking. And it matters for a couple reasons. So again, I just want to clarify there are two different things your client might be seeking to expunge. One would be a delinquency or CHINS finding. So that actual JD case or actual CHINS case in those court records. So that way you would just get rid of those similar, an analogous way to a criminal expungement. And then the second or more common is to actually get rid of that substantiation from the assessment that put them on the Child Protection Index. And it matters which your client wants for a couple reasons. First, because it impacts where you file. If you're trying to get rid of the CHINS or juvenile delinquency record, then you must file in the county where the original action occurred. So you have to file it in that juvenile court in the county where the CHINS or JD case was. If you're seeking to expunge DCS substantiated history, then you file it in the county where your client resides currently. So even if, say, they were living in Vanderburgh County, there's a substantiation against them for child abuse, but they're now up in South Bend, you file it in South Bend if they want to get rid of that record. So that's one of the biggest things that can impact whether you'll be able to proceed, because otherwise the court will have to kick it out if you filed it in the wrong county. But also it's important to note, most folks, when you're filing these, because it's not a common pleading, it's a niche practice area, you'll look to the CHINS bench book forms online, or if you just Google it, that's usually what comes up. And that's on the Indiana court's website. I can share a link after, but one of the reasons I offer a word of caution is because the form they have in there only cites to expungement of CHINS records at 3139.8. So what we will often see is you'll go through the time to prepare that, and it says that you're seeking expungement of certain CHINS records, and I'll see it filed and get assigned, and I'll reach out and have to say, is that really what your client wants? Because I don't see a CHINS history. Is it actually that they want to get off the Child Protection Index? Because if so, you need to file a petition under 3133.27.5, which is a different statute. So all that to say, pay attention to what they're actually wanting. And that is a Word document, that proposed motion from the bench book forms website. And you can just amend that expungement language to the proper one. So it's still a good form to use, but just make sure you're updating it with the proper statutory sites, because they don't have a template in there for expungement under 3133.27.5. And I'll say we have been pretty flexible about trying to amend that by agreement. We're not going to make a stink about it, but it will just save some time for you all in the long run if you can get the proper one filed, and we don't have to reconvene for another status. And when you're filing an expungement record, it's also when you're filing for expungement of a CHINS record, it is actually a very high bar. And I think also that catches some practitioners by surprise, and it's good to maybe be aware of that going into these hearings. And as you're speaking with clients in preparation, it's the clear and convincing evidence standard. And there's really two things that you have to show. The court can grant an expungement petition if it finds by clear and convincing evidence two things. One, that there's little likelihood the petitioner will be a future perpetrator of child abuse and neglect. And two, that the information has insufficient current probative value to justify its retention in the records of the department for future reference. So those are the two things by a clear and convincing evidence standard. And I'll say, just for your reference, there are two published decisions on point around expungements. It's the GE case from 2015 and the RM case from 2023. So if you have one of these cases come up, go to those two decisions and they'll give you a framework for how to move forward. So that's the nutshell analysis of expungements in CHINS and DCS records cases. again, a niche area, but there are a couple of things to keep in mind. Always feel free to reach out as you're preparing one of those if you just want to have a conversation about what that might look like. I also want to talk about a couple recent legislative changes. Again, they may impact you to different degrees depending on how much CHINS or termination work you do or adoption work. But I think they're important changes that maybe reflect the current in Indiana and where future legislation might head. Both of these bills were effective upon passage. So while the Indiana Code website won't show you these updates until July 1st, they have been the law since March. The first is House Bill 1310. It's pretty straightforward. It's been called the concurrent planning bill. And if you're aware of CHINS permanency planning, once a child's adjudicated a CHINS, every 6 months the court has to consider the child's permanency plan and approve a plan, whether it be reunification or adoption or guardianship or placement with a fit and willing relative or another planned permanent living arrangement. But this statute says that if at the time of a CHINS review or permanency hearing, a child has been removed from parents for 12 of the most recent 22 months, the court must approve at least one plan other than reunification of the child with parents. So obviously this only applies where we have 12 months of removal and that DCS is still recommending reunification with parents as one of the plans. If that's the case, the court is obligated under statute now to also authorize a second concurrent plan, whether it be adoption or guardianship or fit and willing relative. So the court was often approving concurrent planning, but I think the fact that it's mandatory changes the dynamic some. And I also think it can be difficult for parents who are your all clients to hear that they're doing pretty well in a case, and then at the same time the court might approve a permanency plan of adoption as well. So just a heads up, it's a statutory obligation, and it will allow, I name it here mostly so if you're practicing, you can give your clients a heads up that may be coming, and it doesn't necessarily pretend what's going to happen in the case, but it's something the court's now obligated to do. The second major change that I think will impact more folks was a significant rewrite of the termination of parental rights statute in Indiana. House Bill 1369 contains substantial changes to an expansion of the termination of parental rights statute in Indiana. The General Assembly drew heavily from Florida's termination statute in drafting it. And for those of you who are familiar with the old iteration of the statute, the new statute now only requires basically three things. One, that there's a satisfactory plan for the care and treatment of the child. That is most often adoption. Two, that termination of parental rights is in the child's best interest. And three, the existence of one or more of the 12 circumstances that are outlined in the new statute. And I won't read through all of them, but I think there are a few that I just want to highlight so you can get a sense for how expanded this statute is. There are some of the old ones that were part of the termination statute, reasonable probability that conditions that result in the child's removal won't be remedied, reasonable probability that continuation of the parent-child relationship poses a threat to the child's well-being, safety, physical health, or life. Those are substantially similar to what used to be there. As was the child was on two separate occasions adjudicated a child in need of services. So it sort of restates some of the older provisions. But there are also some new ones. One is that 90 days have passed since DCS filed its CHINS petition, and the location or identity of the parent is unknown despite reasonable efforts to locate them. Another is that the parent has failed to substantially comply with the dispositional decree for 12 months. Or, and this one is, I think, striking because it shows how different the statute is, that the parent is unlikely or unable to substantially comply with the child's dispositional decree. That's a pretty broad basis for termination. And also note there's no time frame requirement anymore in this new termination statute. In the old iteration, you had to either be have the child removed 6 months after the dispositional decree was entered, or 15 of the most recent 22 months. That time frame is no longer a part of the equation. DCS need not wait 6 months to file a termination petition, and the court need not wait 6 months to terminate the parent-child relationship. I don't think that we will be seeking to do so before that 6-month mark very often, but it's a notable shift in the law in Indiana that we're taking that time frame requirement out of the termination statute. There are some other provisions included that I think are probably less controversial than a parent might be unable or unlikely to comply. If the parent's incarcerated and expected to remain incarcerated for a significant portion of the child's minority, that's one of the factors. If the parent has an extensive, abusive, and chronic use of alcohol or controlled substance that makes them incapable to care for the child, and they've refused to participate in available treatment during the 2-year period before our involvement. Here's one I think will come up a lot. If a child tested positive, if the child's meconium or blood screen or urine screen tested positive for a controlled substance at birth, and mother had one other child who tested positive similarly and had the ability to participate in substance abuse services, that's a factor. If the child was conceived as a result of human trafficking, rape, child molestation, sexual misconduct, other offenses, and finally, if the parent's required to register as a sex or violent offender. So again, as you can see, that's a lot of different factors. It's a laundry list. I didn't mention all of them, but worth taking a look at that because it does significantly expand the ways in which the department might prove up the petition and that the court might make its requisite findings. So something to be aware of as you're practicing. So those were the two main things I wanted to address with legislative changes. There were a few others, but I think those are the changes that will most impact child welfare practice that you might see in private practice, or if you're picking up a public defender termination position, or just being consulted on one. I'll turn to what might be some better news that's related, and that's when it comes to adoptions. Effective July 1, there are significant changes to the subsidies that DCS will offer in adoptions and guardianship assistance. We are now raising the base amount for subsidies associated with the Indiana Adoption Assistance Program and the Guardianship Assistance Program. And now it will be 100% of the amount a child would have been entitled to while in foster care. So if you're representing a foster parent who was getting, say, $33 a day as a per diem to provide care for this child, there is now a presumption when you're negotiating for the adoption that they will get that same amount. So what this will likely do is eliminate the need for a lot of negotiations on the adoptive attorney's end, which will hopefully shorten that timeline between termination or consent to adoption and getting to a final adoption with an adoptive parent. And the hope is it will also help eliminate some financial barriers that some pre-adoptive homes have and difficulties when they're thinking, well, I might get half as much money as I had to provide for this medically fragile child. I'm not sure I can do that. We're hopeful this will address some of those concerns. And to be frank, I think it takes a lot less time on the attorney's end than in the negotiation process, because you're getting a settled amount offer right up front that everyone has to date been happy with. So hopefully that will improve things. I should note it's only impacts adoptions and guardianships finalized July 1 or later. So you may all have folks reaching out to you. You handled an adoption for them previously. So families can still request modifications once every 12 months post-adoption. So I think folks would be encouraged to consider that. And that may be something that they're interested in doing, and you may want to have conversations with clients about that. And there's also a really helpful frequently asked question website available that I can pass on if that's an area of practice for you, where you get some questions about adoptions. Feel free to reach out, and I'll get that info out to you. I also want to mention a word of warning about adoptions. So this is the less nice note that I wanted to address. In the last 24 months, we saw some significant changes in the adoption statute. And if you've practiced adoption law, you know that 3119 is a bit of a maze in Indiana. And it's been made further complicated, especially for attorneys who are representing biological parents in related matters. So you might be representing a dad in a JP, or perhaps parents in a CHIN's case. And that's where I think it gets complicated. One of the first things that's complicated is where the adoption petition actually gets filed. That has been expanded. So now the adoption petition can be filed where the petitioner resides, where the government agency having custody of the child's located, where the child resides, or this was the big add-on, where the attorney maintains an office. So that means even if there's a paternity cause, a DC cause, a CHIN's case in St. Joseph County, you'll often see the adoption petition filed in a different county. And most often, to be frank, that's Hamilton County, because that's where one of the primary adoption attorneys in the state practices. So that's where that firm files most of their adoption petitions. So that poses obvious challenges if you're representing a client who's trying to contest that adoption, because then you have distance, expense, money, the fact that most of us don't practice on a regular basis in Hamilton County. I don't know how many of you have. I had to be down there last year, and it was a terrible experience, and I got a parking ticket. So 2-hour parking around the courthouse, don't forget that. That's my only real pro tip for Hamilton County. That's very difficult, but also what's added is they have shortened the time to respond for parents in adoption matters. The notice requirements are quite convoluted in the Indiana Code. And I'll say, if you're looking for a guide through that, Magistrate Palando in the practice series has a very good overview of the notice requirements in adoptions. But the big takeaway is, in the last year, a parent's time to contest the adoption has been shortened by half. They only have 15 days from the date of notice to file a motion to contest the adoption. And I want to offer a practice note when contesting an adoption. One, you have to file the motion to contest in the court in which the petition was filed. You have 15 days after service to do it. And there's a third requirement that's often missed. You can't just say, I contest the adoption. The motion must set forth the basis on which the person is contesting the adoption. That can be very simple. You can say, parent does not believe adoption is in the child's best interest, or something similar. But there has been some appellate guidance that suggests that that is a mandatory requirement in the code. And I've also seen many adoption petitioners seek to dismiss a motion to contest on that basis. So 2 big takeaways: if you have one of these come up, make sure you're getting it on file within 15 days of service, and make sure your motion to contest sets forth the basis on which you're contesting. Also, advising clients that typically a public defender will be appointed for them in those contested matters if they request that. But I have seen that be county dependent as well. I'll also add, just in the last 2 weeks, we've seen appellate opinions come down that have taken a very hard line toward biological parents on those timeframes set forth in statute in the adoption code. So something to keep an eye on if someone comes to you asking about them. Prompt action is really required. Otherwise, their consent will be irrevocably implied, and there's no working around it. An additional matter that has come up a lot with folks who maybe don't normally do CHINS law is custody or parenting time changes in CHINS matters. And over the past 10 years, our appellate courts have emphasized that to DCS and to local trial court judges that where a CHINS case is pending, there's the ability for the juvenile court, where there's proper notice and hearing, to modify custody to a non-offending parent in order to alleviate the need for a CHINS adjudication and for DCS involvement. And in other words, the appellate courts have made very clear to us, look, if you have one parent who's non-offending and they can do what they need to do and a custody mod could protect the children appropriately, then juvenile court, you can do that. And that's an appropriate path to take to alleviate the need for state involvement. DCS is very open to this approach. I think many of our, particularly in Kosciuszko, Marshall, Elkhart, St. Joe counties, I found that the judiciary is very receptive to this. And the statutory mechanism, as many of you probably know, is found at 3131.12 and 3131.13. And I just want to offer a few takeaways from those that you can file away if you ever need it. One is that the JP or DC court has concurrent original jurisdiction with the juvenile court. But there's a qualifier to that. If there's an active CHINS case, there's an active juvenile case or a delinquency case, or active CHINS or delinquency, then any order entered in that JP or DC cause is only effective if the juvenile court and the CHINS or JD matter enters an order approving it or terminates the CHINS or JD matter. So again, you might be able to go out and get a custody order in the JP cause in front of Magistrate Rukowski, but until the relevant CHINS court adopts it and enters it, it's functionally stayed. And another important point is that if the CHINS court or JD court modifies child custody, parenting time, support, then that order survives closure of the CHINS case. And it will be entered into that. It will be the standing order until the JP or DC court reassumes primary jurisdiction and wants to address all those issues. And at that point, someone can file a motion to modify under the applicable modification statutes, if you say, but you then have to show those change factors that apply. So I think just a simple example of this is you have a completely hypothetical example, but you have a mom who was pulled over with the children in the car. Perhaps she was driving intoxicated. There's an active JP cause. They previously had parenting time pursuant to the guidelines. DCS gets involved, detains the children to father's care. By the time of the fact finding, DCS files a motion to modify custody and dismiss the CHINS, saying that dad can provide appropriate care and supervision of the child, asking for supervised parenting time only for mother, unless and until modified by the DC court or JP court, whatever it is. And we provide notice to mother and opportunity for her to be heard on that proposed custody mod. If the court makes the appropriate findings, that becomes the standing custody order, and that's the order to modify. It's a good result because it often gets the child with a previously non-custodial parent who can provide good care and it keeps DCS from getting formally involved for what can sometimes be months or even years. So it's a good mechanism to use with clients who are non-offending parents. And also, to be frank, I think it's good if you're representing quote unquote offending parents, because it means that they can actually use the custody modification procedures once they get things in order to potentially regain parenting time with their child if appropriate. But so again, that's a strategic decision, but I do think there's some real virtue in that approach, and it keeps DCS from getting involved in too many cases. The final topic that I wanted to address that comes up very often are guardianships, and particularly where there's an active CHINS case. And I think a lot of judicial officers have gotten this wrong over the years, as the appellate case law makes clear. A lot of DCS attorneys have gotten it wrong. A lot of private practitioners have gotten it wrong because it is convoluted. So the guardianship statute and its relationship to venue in CHINS proceedings is pretty strange. So I'll say that if you're seeking a guardianship where there's an active CHINS case, you have to file for that guardianship because exclusive jurisdiction and venue is with the juvenile court where the CHINS action exists. So I've often seen that they say we'll have a CHINS case in Marshall County, but someone wants to file for guardianship with grandma and who lives in South Bend, they'll file for the guardianship up in St. Joe. You can't do that where there's the existing CHINS. The appropriate place to file that would be in Marshall Circuit Court, would have been previously in front of Judge Palmer. So jurisdiction and venue is in the CHINS. The CHINS court gets exclusive jurisdiction over any guardianship where there's an active CHINS case. And then if the juvenile court closes the CHINS case after creating the guardianship, the juvenile court order creating the guardianship survives closure of the CHINS. And then at that point, the probate court may assume or reassume jurisdiction of the guardianship. There's a statutory mechanism of that for that. So the real takeaway is 3130-1110 gives the juvenile court exclusive jurisdiction in guardianship proceedings where a child is a CHINS. And that also means that the permanency plan in the case will need to be guardianship in order for a guardianship to be entered. So I don't think this will come up a ton in your practice, but I have gotten numerous questions over the years on this topic. So maybe just bookmark it or note that that when you see a guardianship and there's an active CHINS, it's going to change your analysis. And anytime you have a jurisdiction question on CHINS, go back to 3130-11. It will be the best starting point for you. And in that regard, just in closing, wanted to offer a few general recommendations. You heard me mention the practice series earlier that, as many of you know, Magistrate Plando now authors. It's a great resource, and obviously not shockingly, Magistrate Plando finds it persuasive since he was the author. So I'm not sure how many of you have subscriptions to it or able to, that's part of your plan, but if you have a complicated issue in juvenile law, it can be really helpful to pay it a visit and at least get a starting framework for analyzing the issue. And again, it's typically found pretty persuasive given that he's a presiding magistrate at the juvenile court. And it's just good analysis. It's very a helpful starting point to start working through some of those issues. There's also a more general resource called the CHINS Desk Book that Kids Voice of Indiana maintains, and that's publicly available. You just Google it. It's out there. I can also get you a link. But it also has, it's broken down into various subject matter topics from initial pleadings all the way through to termination, adoption, guardianship. And it can be a quick one-stop shop to get a succinct summary of the issue and relevant case law to cite to the judiciary or to DCS or whomever. It's very helpful. So, and it's free, which is great. So it may be a bit dated now. I think the last update was maybe 2019, 2021. I can't remember, but so, you know, you'll want to check some things, but in general, it's a very good starting point, a very good resource. If you have a CHINS case and you haven't done it for a while or need to brush up on something. Finally, DCS has all of its policy and practice manual online, readily available. Really, that's also a great place to go to see, is DCS doing what I need them to do? Or why are they doing whatever they're doing the way they are? Typically, you can get a pretty quick and succinct answer with the relevant statutory sites, whether state or federal, in that DCS practice guidance. And that's also available on the DCS website. If you want the link, I'm also happy to provide that. But those are all good places to start if you get a novel issue or one that you're not quite sure how to navigate or have some concerns about how it's being handled. And I'll also add that DCS Council in St. Joe County and throughout the region, I hope your experience has been what George mentioned, which is we are always more than happy to respond to questions, try to get you on the right track, even where there's maybe vehement disagreement. Hopefully have a good conversation that will get us to a agreed solution, and if not, hopefully litigation that, if contested, is done well and respectfully, and actually is a model of hopefully how to litigate well. I don't know if it always happens that way, but that's the goal, right? So always feel free to reach out if you're having issues. Also, always feel free to reach out to me for those conversations, or if you're encountering issues anywhere in the region or the state. I can almost always get you to the right person in pretty short order, or at least get you the guidance that can get you there. And that's my goal, to do that. I'm always very happy to do that. And the final thing I'll say is that our current local office director, Terry Zornig, is retiring after about 3 decades. And so that's a great loss for us. If any of you know Terry, she has a lot of connections in the community. She's been working in child welfare for her entire life. So we're going to see a transition there, which I don't think will impact practitioners much, but that's the person that ultimately signs off on adoption negotiations, some of those issues. So if you know Terry or have worked with her, feel free to send her a note in the coming months. She'll be headed out in October. She'll be entering a much-deserved retirement. So I see there's some questions in the chat. If you have others, feel free. So I see Stephen asked, does request for appointment of public defender extend bio parents' time to respond to adoption petition? Yeah, I don't know how courts in Hamilton have been treating that. I think they still need to appear and contest. That's the side I've been erring on, because I'm not sure that there's a couple different judges in Hamilton that hear most of these, and I'm not sure they've been treating them in the same way. So I think there are some judicial officers who would say absolutely. And I think there are others that would say, no, it's a hard and fast rule. You can show up and contest, and maybe they'll make a record of it. So I guess, but I still think advising them to do that is going to be important. And then Barb asked, so if that custody is modified and CHINS is closed, must mother secure her own substance services? Yeah, and so that's, I think that's ultimately ends up being a question for the court that had concurrent jurisdiction over the DC or JP cause. That is a modification appropriate? And I guess mom getting those services and being able to appropriately parent the children, again, might be one of those factors you could cite. And I haven't often seen a Chins Court order services as a part of that case closure order, and that may be a bridge too far. I don't know how comfortable they'd be doing that, but it may be required for her to later seek a modification of the standing order. And is DCS able in the current climate to encourage or obtain guardianships in Chins cases in order to close the Chins? Well, with care, I guess. I think if there's a court-approved plan of guardianship, a GU cause is created, and there's an opportunity for all the parties to be heard on the guardianship and the petitions properly filed, then yes. There was actually a published reversal of a similar case out of Shelby County issued yesterday by the Court of Appeals. And in that case, the Chins Court sua sponte entered a guardianship. The kids were actually in mother's care, but grandparents were appropriate, had previously provided care, and they had a previous guardianship. The judge in Shelby County sua sponte ordered that guardianship, set it for hearing that afternoon. No petition was properly filed. And mother didn't actually appear at that hearing, and the court entered the guardianship and closed the Chins case. And the Court of Appeals reversing the published decision yesterday. So I guess I would say, yes, it's possible, but we're still going to have to follow the strict requirements of Title 29 around guardianships. Okay, so Mark asked, how often does DCS proceed with a TPR if biomom is receiving services, but the child has been in foster care for greater than 15 months, and it is the third time the child has been deemed a Chins? That is going to be really fact sensitive. I think if you have a Chins court making compliance findings and saying that this biological mother's doing what she needs to do, then that would certainly impact it. I think what providers have to say would certainly impact it. I think what the child's therapist has to say would impact that. So that's where it becomes pretty complicated on our end, because chances are if it's a termination with that sort of history, with that length of time and care for the child, we're going to have numerous experts and service providers who are going to weigh in on what's in that child's best interest, and that's going to impact our analysis. But I will say I have seen cases where the court has entered a waiver of reasonable efforts order, and a parent has gone out and engaged in all the services on their own, paying for them on their own, and we've ultimately reunified. So I think that until that, and I've heard multiple judicial officers say this, until I enter that termination order, you can still be trying to engage and do what you need to do to reunify with your child. So it can happen, but I will say, yeah, the longer a child's been out of care, the more difficult it is to find a CASA, to find a therapist, to find others who've been working with the children to say returning the child's in the child's best interest if there are still these underlying issues going on. Now, if a parent's addressed all of them, it's a different analysis. So that's sort of a long-winded non-answer saying it depends. Okay, does DCS have either a formal or informal method of dealing with abusive DCS hotlines? That is, a parent who constantly reports the other parent. And actually, this would have been a great topic to address, Tanner. I didn't even think of it, but DCS doesn't have the method, an informal method, but there's a statutory mechanism. The General Assembly has said that if a parent has an issue with that, the person they reach out to is the local prosecutor. It's actually, they take it out of DCS's hands because it's a potential criminal offense, false reporting. So, and again, I can pass on that statutory site, but So ultimately, they would make a complaint to the local prosecutor's office, and the prosecutor can make a decision about whether they want to investigate and move forward. I will say this does happen on occasion. We've gotten those written requests and turned over hotline recordings and other issues where there's an active investigation of potential false reporting. So yeah, there's a statutory mechanism. But I will say, Tanners, I think you're aware, report source is protected by statute. So often a parent will suspect or seem adamant that they know who report source is. And really there's no way for them to know that with certainty. Ultimately, that would be something that the prosecutor's office would make a determination on. And I'll say that oftentimes people get it wrong when they're positive that they think they know who it is. And that's not always the case. But yeah, there is a mechanism for that. I believe there's a DCS policy that addresses that as well in our practice manual that is publicly available. You can take a look at. Any other questions, thoughts, feedback, concerns?
All right, I think I'll call it then. Thank you very much, Richard. This was all very, very helpful. Especially as Chin's Law starts to integrate more with the adoption proceedings that we may do, the custody proceedings we may do. That adoption statute's a crazy one. I think we can all probably agree. I find it interesting that you have more time to object to someone suing you in small claims court for $600 than you do to an adoption. So I look forward to the appellate cases and Supreme Court cases that will undoubtedly be taken up. So with that, I think we'll conclude today. Again, I want to thank Richard on behalf of the Family Law Committee for presenting. This was hugely helpful. If you guys have any follow-up questions for Richard that you may have not thought of, you can go ahead and send those to me. I'll try to get you some answers on those. As a reminder to everyone, our next meeting, and we may have one in between, but the next, I would say, big one that definitely will be a CLE is going to be August 29th at noon, and that will have Magistrate Orlando presenting with updates. As we heard, he does the practice series, so he'll be presenting to us as well. Does anyone have any family law committee questions in general before we sign off today? All right. All right. Well, very good. Everybody have a good rest of the week.
Thank you. And everyone, it looks like Richard just put his contact info in the chat if you needed that.
Thank you. Thank you.